Hey everybody, it's Atheist for the Cause with another article review for you. This one is about how there's been another court ruling on Trump's travel ban. It says here another U.S. court rules against quote-unquote Muslim ban, but we know it's a travel ban that also impacts non-Muslims. A second U.S. appeals court today ruled against President Donald Trump's temporary travel ban on people here. They call it a travel ban here. Funny how that works, because they know a lot of people aren't going to get past the headline. So if you just put that in the headline, that'll misinform a lot of people in the way that the propagandists want. And then they'll tell the truth in the details where fewer people are reading. So Donald Trump's temporary travel ban on people entering the U.S. from 6 Muslim-majority countries, largely upholding a lower court's decision. The Ninth U.S. Circuit Court of Appeals in San Francisco was reviewed a March ruling by a Hawaii-based federal judge that blocked parts of Trump's order. The ruling came after a separate court, the Richmond, Virginia-based 4th U.S. Circuit Court of Appeals, on May 25th, upheld a Maryland judge's ruling blocking parts of the order. On June 1st, the Trump administration asked the U.S. Supreme Court to block the Hawaii and Richmond rulings and revive the ban. So that's what's happening here. Headed to the Supreme Court, where Trump has a much better chance of winning, because the first 2 courts were, purposefully put into more liberal courts or progressive courts, whatever you want to call them. And the U.S. Supreme Court is more of a conservative court. So I wanted to give a couple angles of this. This from the Washington Times. Appeals court upholds halt of Trump travel ban, but allows DHS to improve vetting, which this other article didn't mention. If you actually read the details of what the court is ruling, the court ruled way differently than the first court did, and not the entire thing was shot down. They're basically saying that the Trump lawyers, the government, didn't make their argument they didn't have enough evidence that these countries that are being restricted have some sort of increased risk. But they recognize the ability of the president to limit immigration. A federal appeals court rejected President Trump's attempt to revive his extreme vetting travel ban Monday, ruling that the White House never managed to prove it needed such a broad policy, which would temporarily halt the refugee program and put pause on most admissions from 6 terrorist-connected countries. Okay, 6. Can't remember if it was 6 or 7. Unlike other countries, the judges didn't base their decision on a perceived animus display by Mr. Trump against Muslims. Instead, the judges peered behind the curtail at the president's decision-making and said they found it lacking. This tells me, when the ruling, the logic behind the ruling is completely different, it tells me that the lower court was out of line. And now they're trying to give better, logic. It sounds to me like this court's trying to give better logic behind the ruling. And the judges also threw Mr. Trump's own words back at him, pointing to his series of tweets last week as new evidence he's improperly targeting countries. The ruling is the second appeals court decision to halt at least part of Mr. Trump's executive order, though this decision is by far the broader one, halting not only extreme vetting of visitors from Iran, Libya, Somalia, Sudan, Syria, and Yemen, but even denying Mr. Trump the power granted in law to set the number of refugees admitted each year. Still, the judges did say the Trump administration can go about improving its vetting procedures, even while it can't pause admissions. And that was like the only, basically the court wants Trump to work with Congress on that. But I'm not sure that there's actually justification for that, because presidents seem to have changed the number of immigrants in the past. But it's possible, because if there is some sort of legislation, and I don't know, I'm not 100% if there is or not, that there has to be a certain amount of refugees and immigrants allowed in, well, then that would be a law that the president would have to follow. But if it's not actually law, then the president might be able to just change the number, and the U.S. Supreme Court will have to decide that. It says the far-left U.S. Court of Appeals for the Ninth Circuit said Monday that President Donald Trump's March 9th executive immigration order on refugees is unconstitutionally vague. That's really what they're hanging all of this on, is that they keep pointing to vagueness, but the three-judge, and this is from Breitbart, by the way, the three-judge decision declared that President Trump must justify his policies in court by citing agency recommendations, and that cannot unilaterally curb the annual inflow of refugees from 100,000 to 50,000. And even though prior presidents have raised and lowered the annual inflow of refugees without interference from the judges. Immigration, even for the president, is not a one-person show, the judges declared in their 86-page decision titled Continuing. By the way, I want to show you something real quick. Obama administration originally flagged 7 countries in Trump's order. And this is on the Hill, so this is showing that in February 2016 that Obama administration added Libya, Yemen, and Somalia to the list of countries of concern. And Iran, Syria, Iraq, Sudan were already on the list from the administration original law in 2015. Here from PolitiFact, the travel part of Trump's order does target the same 7 countries that were singled out with the law Obama signed in December 2015. The Obama-signed law contains provisions that restrict travel to the United States for people who lived in or visited Iran, Iraq, Sudan, or Syria since March 2011. They must have a visa to enter the United States. They can't use what is known as the Visa Waiver Program, which allows 90-day U.S. visits to other foreign visitors. And what's funny about this is that the courts are using they're using Obama as part of their justification when they like something Obama did, but then they won't continue that justification to saying that these countries listed are problematic countries. And you'll see what I'm talking about in a bit. I'm going to read some of these court decisions. It says, to justify its... Well, let's start here. The president's authority... These are all court decisions. The president's authority is subject to certain statutory and constitutional restraints. We conclude that the president, in issuing the executive order, exceeded the scope of the authority delegated to him by Congress in suspending the entry of more than 180 million nationals from 6 countries. 180 million nationals? I guess it wasn't just Muslims, huh? Suspending the entry of all refugees and reducing the cap on the admission of refugees from 110,000 to 50,000 for the 2017 fiscal year. The president did not meet the essential precondition to exercising his delegated authority. The president must make a sufficient finding that the entry of these classes of people would be detrimental to the interests of the United States. Oh, really? So these high-risk countries, according to Obama, and obviously the Trump administration agrees, aren't detrimental to the interests of the United States, especially when we're fighting wars in many of these countries? Give me a break. Further, the order runs afoul of other provisions of the INA that prohibit nationality-based discrimination and require the president to follow a specific process when setting the annual cap on the administration of refugees. In the INA of 1952, Congress delegated some of its power to the president through Section 212F, which provides, whenever the president finds the entry of any aliens or of any class of aliens in the U.S. would be detrimental to the interests of the U.S., he may, by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose the entry of aliens and restrictions he may deem to be appropriate. I don't know. Sounds like he has the authority to me. But I'm no lawyer or judge, so we'll let the U.S. Supreme Court decide it. Section 1182F of the law requires that the president find that the entry of a class of aliens into the U.S. would be detrimental to the interests of the United States. This section requires that the president's findings support the conclusion that entry of all nationals from 6 designated countries, all refugees in excess of 50,000 would be harmful to the national interest. There is no sufficient finding in EO2 that the entry of the excluded classes would be detrimental to the interests of the United States. There is no finding that the present vetting standards are inadequate, and no finding that, absent the improved vetting procedures, there likely will be harm to our national interest. These identified reasons do not support the conclusion that the entry of nationals from 6 designated countries would be harmful to our national interest. Given that ISIS and other jihadi groups have said they're trying to use these programs to get into the U.S. and commit attacks, and they have done it successfully in Europe, such as in France, where one attack killed like 100 people. And it was because they got a fighter in through the refugee program. So the risk is real. The order does not tie these nationals in any way to terrorist organizations within the 6 designated countries. It does not identify these nationals as contributors to active conflict or as those responsible for insecure country conditions. This is what makes me think that the government's holding a lot back, because this is easily shown. I mean, Syria's in a freaking civil war, and we're involved in Syria, we're involved in Iraq. I mean, it's hard to say that there's no insecure country conditions when people of these countries are fighting our troops. It does not provide any link between an individual or those allied with us. It does not provide any link between an individual's nationality and their propensity to commit terrorism or their inherent dangerousness. Well, I don't know about inherent, but in short, the order does not provide a rationale explaining why permitting entry of nationals from 6 designated countries under current protocols would be detrimental to the interests of the U.S. In conclusion, the order does not offer a sufficient justification to suspend the entry of more than 180 million people on the basis of nationality. National security is not a talismanic incantation that, once invoked, can support any and all exercise of executive power under Statute 1182F. Sorry, my voice is killing me still from the football game, so I'm trying to power through this. But this is the part where the court's going to rely on President Barack Obama's judgment. The upping the inflow of refugees to 110,000 a year is safe, saying. Now remember, these are the countries that Obama pointed out as high risk. President Obama previously determined that the administration of 110,000 refugees to the U.S. during fiscal year 2017 was justified by humanitarian concerns or otherwise in the national interest. To the extent that 60,000 additional refugees can be considered a class of aliens, EO2 makes no findings to justify barring entry in excess of 50,000 as detrimental to the interests of the U.S. EO2 gives no explanation for why the 50,000 and first to the 110,000th refugee would be harmful to the national interest, nor does it specify any further threat to the national security. Really? So, more refugees and of high-risk areas doesn't further the threat to national security? Now, maybe they didn't specify it because they're holding their info for the Supreme Court. But I would say that the risk from 1 to 50,000 would still be there. But as you get more refugees, the risk goes up exponentially, and you start getting in mass immigration, to even if it's refugees, where the more you have, the more they'll create communities that are problematic. Because when they build these communities, they are less likely to integrate. So you want to spread them out so they integrate and keep the numbers low-ish. And there is not any rationale explaining why the previous target admission of 110,000 refugees this fiscal year was justified by humanitarian concerns. You know what I don't get about this? It's like, okay, Obama determined 110,000. Why weren't 150,000? Okay, why weren't 250,000? Okay, why weren't 500,000 like Hillary Clinton wanted? Okay. But they didn't use that logic for Obama. And there is not any rationale of why the previous target administration of 110,000 refugees this fiscal year was justified by humanitarian concerns or otherwise in the national interest. See 8 U.S.C. Statute 1157A2. But that entry of more than 50,000 refugees the same fiscal year would be detrimental to the national interest. Here, too, the president did not meet the statutory precondition of exercising his authority under Statute 1182F to cap refugee admissions. So, that's what the court's saying. Breitbart links the full decision if you want to read it. And I have a feeling that it's going to go through the Supreme Court and deemed legal. But we'll see. And hopefully the government can do a better job arguing their case. They might be holding on to it for the Supreme Court so they don't give away their cards. But I think in the end, we'll see that you can already see a shift in the court's logic from the first lower court ruling to the appeal court ruling. The logic is completely different, where they tried to say that Trump was actually, in the lower court, that Trump actually had like some sort of vendetta against Muslims, or, animus is the term that they used in the higher court. So, anyways, I'll talk to you guys later, and we'll see what happens from here.